Hello friends, I welcome you all to lecture number 10 of Clat lecture series sponsored by Sri Jendra Rank Zone. I'm your mentor Shekhar Gehlot. We are discussing criminal law and the basic concepts of criminal law. Okay. Today's class will begin with other offenses against body. See, this we are continuing. Okay, we had begun in our next previous chapters, we had started working on offenses against human body. Okay, and we discussed murder and culpable homicide. Now we shall proceed to another category of offenses which could be committed against human body. Okay, so the first offense, okay, after murder. Okay, murder is the most heinous and most severe offense against a human body. That is why we did it in the initial. Now let us proceed to other offenses. Other offenses, simple hurt. Okay, offense which could be caused against a human body is simple hurt. Hurt simply means something which causes a pain in body. How much pain? That is not prescribed. It must cause pain. Okay. How much pain one particular act causes to someone may differ from person to person, his physical ability and all. Okay. But pain should be there. Okay, it is not, we are not dealing with the gravity of pain. Okay. Gravity of pain is immaterial. Okay, it is immaterial. Okay. Whoever causes bodily pain, disease, or infirmity to any person is said to cause hurt. Okay. Whoever causes these things. Okay. Someone has caused someone a bodily pain, like someone has slapped someone, or someone has punched someone, someone has kicked someone, someone pushed someone and he sustained a fall. Okay. All these acts are called bodily pain. Someone is beating someone with a cane, someone hit you with some object, that will qualify in the case of bodily pain. Definitely, these actions will cause a bodily pain. Whether it would be a heavy pain or it would be a normal pain, that is not the focus here. The pain should be there. Then disease. Okay, if someone causes a disease to you, I am having COVID or viral fever, I deliberately transfer it to you. Okay, I deliberately transfer it to you. It will be covered in the simple hurt, causing disease. Okay, causing disease to someone, or infirmity. Infirmity means your body is not able to function properly. Your body is not able to function properly. There is some damage to your body function. Okay, it is called, but this damage is temporary. Okay, infirmity is temporary. Someone hit me with a cane on my toes or my ankles, may say. Toes or ankles. Okay. With cane and they have swelled up and turned bluish. Now I could not walk properly for 10 days. Why? Because there's a pain in my leg. Okay. There's a pain in my leg. These are the cases which are covered when we talk about simple hurt. Okay. What is a simple hurt? These are the simple hurts. Okay. Or you can also call, or you can also simply say any hurt other than a other than a grievous hurt is simple hurt. You cause a hurt to someone, but that is not a grievous hurt. Any hurt inflicted upon some person by another, which is not a grievous hurt, will be a simple hurt. Okay. Now, what is grievous hurt? We have discussed previously as well, and we are going to discuss just after some time. Okay, after simple hurt, we'll proceed to the grievous hurt. So, simply understand any hurt which is other than a grievous hurt is a simple hurt. And what all could be a simple hurt? Okay, what all could come within the bracket of a simple hurt is causing bodily pain, beating someone, or causing a disease. You are transferring a disease, or causing infirmity, okay, temporary deformity in the body, like we discussed. To any person is said to cause hurt. That is hurt. Whoever does any act with the intention of thereby causing hurt to any person, or with knowledge that he is likely thereby to cause hurt to any person, and does thereby cause hurt to any person, is said to cause what is said voluntarily to cause hurt. Okay, so that means knowledge is essential here. Knowledge or intention to cause that hurt, or your knowledge that by this I will cause hurt to that person, is essential here. Okay, it is essential here. Like we discussed the example, a student places a bomb A student places a bomb or a cracker in the boys' toilet and lights it up. Another student goes to washroom, unaware of such bomb. The bomb goes off. The boy is stunned and suffers pain in the ear. Now, this is a case of causing bodily hurt. Okay, causing bodily pain. There's a pain in the ear. A student is hurt. Okay, but here, if we examine this situation, the student may not be having an intention. The one who placed the bomb, he may not be having an intention
It's
to
11 o'clock.
hurt anyone in this manner. Okay, but he had the knowledge. Okay, he had the knowledge that by doing so, because it's a public area, toilet is a public area, washroom is a public area, and people do use it. Okay, and there is no notice of using it. Okay, nobody displays that I am going to use washroom. People silently go and use it. So usually people will not come to know. Okay, and then someone has hidden a bomb, so it can cause injury to someone. Okay, maybe pain in the ear, or if the bomb blasts very near to someone, it can cause damage to the body as well. Otherwise damage, visible damage. So this person, this student who has placed a bomb in the, okay, or cracker in the boys toilet, he has a knowledge, okay, that something can happen and some student may enter at the same time when the bomb is blasting and he may suffer some injury. He is not having intention. Okay, he does not have intention. He is not doing it intentionally. His intention is to cause a disruption in the school. Okay, his intention is to create mischief. Okay, but he has a knowledge that during this mischief someone may get hurt. So this is also a case of causing simple hurt to someone. Okay, like we are discussing, because mens rea, we again go back to basic principle plus actus rea. Mens rea means you have intention, you have a guilty intention to cause this act. Okay, but simple hurt, they say, even if you do not have a mens rea, okay, even if there was no mens rea, there was no guilty intention of hurting this particular student, then also this student who has placed a bomb will be liable of liable for causing simple hurt to someone because he had the knowledge that something wrong may happen. Section 223 is the punishment for causing simple hurt. Whoever, except in the case provided for by Section 334, voluntarily causes hurt shall be punished with imprisonment of either description for a term which may extend to 1 year, okay, or with fine which may extend to 1000 rupees, or with both. So the punishment is either 1 year. You could be sentenced up to 1 year. Okay. Now, accept the case provided by Section 334. 334 is when you are causing hurt by deadly objects. Okay, you are using deadly weapons to cause hurt. Okay, deadly weapons. You use a machete to cause hurt to someone. You inflict a wound in such a way that there is no grievous hurt, but definitely a very bad hurt. Okay, so that case will go in Section 334. Voluntarily causing hurt shall be punished with imprisonment of either description for a term which may extend to 1 year. Okay, now in this place, okay, here this thing comes into picture. Gravity of pain becomes material here. Okay, gravity of pain becomes a essential object here. Now for committing hurt, gravity of pain is immaterial. Okay, for conviction, whether a person has committed a hurt upon someone or not, gravity of offense is immaterial. But yes, when you are sentencing that person, when a judge is trying to inflict punishment upon that person who has committed hurt, then this bodily pain becomes material. Suppose someone has simply slapped someone and he feels offended. So on first occasion, he may be given just a fine of 500 rupees or 1000 rupees because it's only a slap in a fight. In an argument, someone slapped someone. Okay, so there is not great deal of bodily hurt. But suppose take the example, someone is causing temporary deformity. Someone hits someone with a cane, like we discussed. In 10 days, he is suffering informity in the body. So he may be punished. He may be punished for 3 to 4 months jail term as well, because his gravity is more here. Now, someone is transferring COVID to someone. COVID is such a deadly disease. You transfer it to someone, the whole family of the other person is going to be COVID carrier. Okay, so it is very difficult to survive with this something like this contagious disease. So someone is genuinely with bad intention or with knowledge. Someone has a knowledge. Okay, may not be having intention. Someone has a knowledge that he is a COVID positive. Then also he goes and attends some party. Okay, and some people contract COVID, or someone is doing it intentionally. Okay, he does it intentionally to cause COVID to someone. So in these cases, because the COVID is right now a grave disease which India and the world is facing right now, so judge may sentence him for full 1 year on the first conviction itself, that because you have done something like this disease, you have caused a disease, you should be sent to imprisonment for 1 year, or collection of water in house coolers, etc. You are collecting waters in your house coolers, you are not cleaning them. Okay, it becomes breeding ground for dengue mosquitoes. Dengue mosquitoes, and someone is contracting dengue, and it turns out that the dengue mosquito was breeding in your cooler, and you did not clean the cooler as advertised or as suggested by the government and the various civic agencies, then definitely your act could come up within this disease section. Though you are not doing it intentionally, you have no intention to breed dengue mosquitoes, but you have knowledge that my act of not cleaning the water from the cooler, okay, it can definitely lead to a dengue mosquito which can cause disease. So this is what a simple hurt is all about. Now we proceed to grievous hurt. What is grievous hurt? Any hurt which is not simple hurt. Okay, so in IPC we have only two type of hurts. One is simple hurt and other one is grievous hurt. So we can define them like this as well. Any simple hurt which is not simple hurt is hurt which is not grievous hurt, and grievous hurt is hurt which is other than simple hurt. Okay, that is simple hurts, that is grievous hurt. But section 2 define what is grievous hurt as well. Okay. The following kinds of hurt only are designated as grievous hurt. That means it has given only, when it uses word only, that means the list is exhaustive. The list is exhaustive, the list is not inclusive. That means the list is complete. You cannot add any offense to the list. Okay, you cannot add any other offense to the list. Okay, list is exhaustive in itself. The following kinds of hurt are only designated as grievous hurt. Let us see the following kinds of hurt. Firstly, emasculation. Emasculation means cutting, ripping, or chopping of genitals, male or female. Okay, that's called emasculation. Now, there are somewhere in societies, some families go for forced emasculation or vaginal mutation. Okay, for boys and girls, respectively, and they call it a tradition. Okay, they call it a tradition. So, this tradition is not a good tradition, and if someone is getting something forcefully done, then he can definitely complain, and the act will definitely fall within first clause emasculation. Secondly, permanent privation of sight of either eye. Okay, permanently your sight is gone of either eye. Someone has hit you in such a manner. Okay, either maybe by a punch. Okay, either by a punch or something. Someone has hit you in such a manner that you have lost eyesight in either eye or in both the eyes. Okay, in either eye or in both the eyes. Then that is called a case of grievous hurt. Permanent privation of hearing of either ear. Okay, you have lost the capability to hear either in one ear or in the both ear. That is also a case of grievous hurt. Okay, privation of any member or joint. Okay, privation of any member or joint. So your body, okay, your member, your ligament or your joint is separated. Okay, it's dislocated. Okay, your joint is dislocated by someone. That is also a grievous hurt. Destruction or permanent impairing of the powers of any member or joint. Destruction, okay, or permanent impairing of the powers of any member or joint. Permanently, your powers are reduced. Okay, someone has chopped off your. Someone has cut down, chopped off your finger, your hand, your leg, or your part of your body, your ear, or something like this. Okay, but not regenerative parts. Okay, but not regenerative parts. This is not applicable to regenerative parts. Someone is cutting your hairs forcefully. You cannot treat it as a destruction of hair, okay, or privation of any member or joint. Someone is cutting your nails forcefully. That is also not a part of grievous hurt because they are regenerative. They can fully regrow to their earlier capacity, fully, completely recover. We are talking about body parts which do not recover. A finger once cut is cut forever. Permanent disfiguration of head or face. Okay, permanent disfiguration of head or face. Okay, this clause covers throwing acid or chemical on the face. Okay, or inflicting such injury on the face that it is disfigured. Now we have separate section for acid attack because it has become a rampant mischief in the society, and people who are disgruntled in love affair or marriage usually would resort to such kind of tactics, throwing acid. Okay, and this is being dealt very heavily by the law, and now there is an enhanced punishment. Okay, if someone is throwing an acid, minimum 20 years of jail term is for that person. Fracture or dislocation of bone or tooth. Okay, causing fracture to someone's body part, someone's bone or tooth dislocation. These are causes of grievous hurt. Any hurt which endangers life or which causes the sufferer to be during the space of 20 days in seven body in severe bodily pain or unable to follow his ordinary pursuits. Or any hurt is caused to you which is not having all these ingredients, any of these ingredients. Okay, everything is fine, but someone has beaten you in such a manner, like we discussed this case. I said I could not walk properly for 10 days. Someone has beaten my ankles like that. But suppose if someone has beaten the ankles and I cannot work for 20 to 21 days. Okay, I could not walk, but there is no fracture, only swelling. But swelling is very severe. For 21 days, I could not walk, I could not carry out my duties ordinarily. My body could not function properly for 21 days. Okay, then it will become a case of grievous hurt. Okay, grievous hurt. Clear? This is what is grievous hurt all about. What is the punishment? Whoever, except in the case provided by section 335, that is grievous hurt by dangerous weapons, voluntarily causes grievous hurt, shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Which may extend to 7 years. That means 7 years is the maximum term. Okay, but it means that court can give 2 months imprisonment as well. It is not mandatory that judge has to sentence each and every person for 7 years for causing grievous hurt. Okay, it depends on the case to case basis. It depends on case to case basis, gravity of pain or gravity of injury or the way in which the injury is caused. Okay, they all are factors which are considered by the judge before considering the sentence. So, law has given a discretion to the judge. Okay, option to the judge up to 7 years and shall also be liable to fine up to 7 years. So he can sentence to 2 days as well. Okay, he can sentence someone to 3 days, 3 months, 3 years like this. It is judge's discretion what he feels good in a given case. Now let us do the difference between hurt and grievous hurt. You read it and we'll discuss within 30 seconds. According to Section 319 of the Code, whoever causes bodily pain, disease, or infirmity to any person is said to cause hurt. As per Section 320 of the Code, grievous hurt is caused through specific nature of injuries. So, Section 319, which defines hurt, okay, the difference between hurt and grievous hurt is simple hurt, okay, there is no exact nature of injury is discussed, but in 320 that is grievous hurt. Okay, the law discusses the exact nature of injuries like emasculation, loss of sight, hearing, limb, etc. Simple hurt does not endanger life, while grievous hurt may cause danger to life. Okay, because the gravity of offense, gravity of injury is bigger. Simple hurt is not serious, while grievous hurt is serious in the nature. Okay, simple hurt is not grievous or not serious. Okay. Hurt is punishable when it is accompanied with other offences, such as voluntary causing hurt, etc. Whereas grievous hurt is itself is a punishable offence. Okay, hurt is punishable when it is accompanied with other offences, voluntary causing hurt. Okay, that is a specific offence in section 323. Okay, grievous hurt is itself punishable offence. Simple hurt is little more than frolic with a good nature. Man would hardly resent. Simple hurt is little more than frolic which a good natured man would hardly resent, but grievous hurt is that offense which approaches in economy to murder. Okay. So simple hurt is they are saying that simple hurt is usually something which people usually do not complain. Okay, I am having a fight with someone, he slapped me twice, I slapped him thrice, nobody will complain. Okay, but grievous hurt is something which is just like near to murder. Okay, it can be very deadly. So these are the distinctions. Now we go to kidnapping and abduction. Okay, we are dealing offenses against the human body. So kidnapping and abduction of human body is also another kind of offense which are discussed in the law. Offense of kidnapping is an aggravated form of wrongful confinement, although it doesn't include the offense of wrongful confinement per se. Anyhow, we'll go to this thing later on. Let us first understand what is kidnapping. This word kidnapping, okay, it is derived from the conjunction of two words. Conjunction of two words. One is kid, other is nap. Kid is a child. Okay, anyone who's below 18 usually is a kid. Okay, treated as a kid. And nap means short sleep. Okay, or sleep. Simply say sleep. So this comes from the traditional way of kidnapping. Okay, traditional way of stealing kids was that a kidnapper would take away the child. Okay, this was the traditional way of kidnapping. Okay, because we did not have vehicles and guns and so all like we see in the movies. Okay, you are going on the road and a van comes and will people will drag you inside the van and zoom off. No, earlier it used to be like traditionally kidnapper would usually pick up a small children and give them something in the drink which would cause the child to sleep. That is why we call it kidnapping. Okay, you are putting the kid to sleep, you are putting the kid to nap and then taking him away from his parents. That is called kidnapping. Okay, so kidnapping, simply now you understand what kidnapping is. Taking a Taking a child out of lawful custody without permission. That means that is kidnapping. You take a child out of the lawful custody and without the permission. Without permission of whom? Without permission of person concerned. Okay. So usually the lawful custody. Okay. And we are talking about lawful custody. Okay, taking the child out of unlawful custody is not kidnapping. So lawful custody is usually parents. Parents have the first custody of kid. Okay, then guardians or relatives, or when the student is in the school has the lawful custody of the child. If someone is taking the child out of the school or from the watch of the parents without their permission, okay, then it will become a kidnapping. It will become a kidnapping, an offense of kidnapping. Okay, but taking child out of unlawful custody is not kidnapping. Okay. Someone has kidnapped a child. Other person kidnaps the child from him. Okay. So because this person had no lawful custody, his custody itself was unlawful. So when he committed kidnapping, okay, when he committed kidnapping from this person, then he has not committed the offense of kidnapping. Okay, he has not committed the offense of kidnapping. He has committed. Okay, he can be called a person who has assisted the crime, okay, because he had kidnapped the children and he has further kidnapped from the kidnapper. That means he is preventing the child to be united with the family. Okay, so he can be a accomplice in this crime. Okay, taking child out of lawful custody, unlawful custody is not kidnapping. Okay, now this is all you understand what kidnapping is. Now, what we are discussing here, we say taking a child out of lawful custody. Okay, let's first read other parts, then we'll come to it. Offense of kidnapping is aggravated form of wrongful confinement. Aggravated form means more severe, more severe form of wrongful confinement. Wrongful confinement, like we discussed, is confining someone within the four walls. We discussed wrongful confinement when we discussed law of torts. Okay, so you are forcefully putting someone in such a position that he is not able to move. The other person is unable to move in either direction. Okay, you direct someone to freeze at his location and you are holding a gun that don't move. That is called a wrongful confinement. Okay, so kidnapping is aggravated of wrongful confinement. Okay, you not only confine someone but you steal that person. Okay, you steal that person. Although it does not include the offense of wrongful confinement per se. This we are going too technical, not required for you people. Section 359 deals with kidnapping and it says kidnapping are of two types, from India and from lawful guardian. Kidnapping is of two types, from India and from lawful guardian. Kidnapping from India, conveying a person beyond the limits of India without the consent of that person or someone legally authorized to consent on behalf of that person. The offense would not be complete until the person actually reaches not only a foreign territory but to his destination as well. Okay. So taking someone out of India, okay, taking someone out of India is kidnapping without his permission or permission of lawful guardian or someone who can give a permission. Okay, someone who can give a permission. Okay, like government or other agencies who can give the consent. So you're taking such a person out of the India. Offense would not be complete until the person actually reaches not only a foreign territory but to his destination as well. Okay, kidnapping would be complete only when the child is taken out of India and has reached to the place where the kidnapper is supposed to take the child. Okay, before that destination, it will be an attempt to kidnap. Before that, it would be an attempt to kidnap. From lawful guardian, enticing, taking away of minor, unsound mind person, male under 16 years of age and female under 18 years of age, taking enticing must be out of keeping of lawful guardian and without the consent of such guardian. Now this is the offense of kidnapping which we are largely concerned with. Okay, because cases like these are rare. Okay, they are not as rare, but if we compare it, kidnapping from India to kidnapping within India, okay, from lawful guardian, these have higher chances in higher cases. So what is kidnapping from lawful guardian? Enticing or taking away. Taking away means, taking away simply you take away the child. You come on the bike, take the child on the bike and run away. You come in the car, put the child in the car and drive off. Enticing is when you mm, I'll just give you an example, okay? A goes outside the school. Okay, this is called enticing. You are luring someone, okay, giving allurements, luring someone, okay, making promises or showing attractions, etc. Okay, like we see sometimes in the cases that people lure young children, male and female, for work in cinema industry if they accompany. So enticing is when you lure someone, when you're not taking away is you are forcefully taking the child away. Understand? But enticing is when you are not forcing the child in that sense, but you are giving attractions to the child, you are luring the child, you are making some promises that you come with me. You go and tell a girl aged 15 years that you come with me, you will be a star, you look that good, I'll make you a model, you will be a cinema star, you will be minting crores of rupees and all your dreams would come true. Or you take a child who's below 16 years, male child, that I'll make you a cricketer, I'll make you the best player in the world, you come with me, join me, and this and that. And they are all doing it without the permission of the lawful guardian. Without the permission of the lawful guardian. Okay, then The offense of kidnapping is complete. A goes outside a school. He sees a 5-year-old kid who is not in any way related to or known to A. Okay, this kid is not known to A. A shows an ice cream to child and asks the child to follow. Naturally, the child is 5-year-old. He does not have mind. Okay, he's attracted with the ice cream. So he's not following A, he's following ice cream. So when A says that you follow me, the child who now wants to have the ice cream begins to follow A because he's a child. Offense of kidnapping is complete. Okay, offense of kidnapping is complete. Now let us again read this section. Enticing, now we know what enticing is. Enticing or taking away of minor. Someone who's a minor, who is a minor for this section? Law says male under 16 years and female under 18 years. Or unsound mind person. Unsound mind person, we are not talking about age. Unsound mind person is a forever minor till the time the person is unsound. He may be 60 years of age, but if he is unsound, he will be a minor. Okay, so enticing or taking away of a minor. Minor, what is a minor? If he is not unsound, then male under 16, female under 18, or any unsound mind person, irrespective of age, out of the keeping of lawful guardian and without the consent of such guardian. You take that child out of the lawful guardianship and without the consent of such guardianship. Now, you people must be thinking that A goes out of the school, sees a 5-year-old kid. 5-year-old kid is standing in the on the gate, waiting probably for his parents or school bus or whatever, and he entices the child out of his parents' custody. Now, you must be thinking that what is the keeping of lawful guardian? Keeping of or what is the custody of lawful guardian? Okay, now we have discussed what a lawful guardian is. Okay, it can be a teacher, or it can be guardian, it can be relative, it can be parent, whatever, as the case may be. Okay, but what is the keeping or the custody of lawful guardian? Now, in this case, the child is standing on the road. No guardian is nearby. There is no school. School authorities are not nearby. Relatives are not nearby. Parents are not nearby. So now tomorrow he argues. This person A, he is arrested for offense of kidnapping. He argues in his defense that the child had no guardian nearby. So he was not in somebody's custody. He was not in anyone's custody. So when I enticed him out of when I enticed him with an ice cream, I did not take him out of the lawful guardian, custody of the keeping of the lawful guardian. Why? And because there's no lawful guardian nearby, I do not require the consent as well. Because there was no one nearby, I have not taken the child out of the lawful custody. There was no lawful custody. So why am I being held up for offense of kidnapping? Now the law answers this question in such a manner that every child, wherever he may be, is supposed to be in custody of parents. Okay, every child, wherever that child may be. Okay, now the child is standing on the road. He is still presumed to be within the guard and care of the guardian or the parents or the school authorities, as the case may be applicable. No one has the right to entice anyone, even if he is standing there without any guardian. Guardian is presumed to be present everywhere, and it is presumed that whatever this child is doing, he is doing with the permission of the guardian. So when you interfere with the activities of the child, then you are interfering without the permission of the guardian, and if you incite, the moment child begins to follow, the offense of kidnapping is complete. The offense of kidnapping is complete the moment child follows you. So that is how the law answers this question, that a child is always in the custody of parents or the guardian or the teachers, as the case may be applicable. Okay, now let us see, understand this thing. Let us again read the definition one more time. Okay, enticing. Now we understand what is enticing or taking away. We know what is taking away as well, of minor or unsound mind person, male under 16 years and female under 18 years. Taking enticing must be out of keeping of lawful guardian and without the consent of such guardian. Now, if you read in whole section, okay, nowhere this section does not use the word such as knowingly taking away, or with knowledge taking away, or intentionally taking away, or intentionally enticing, or with intention enticing the kid away. So that means in order to commit the offense of kidnapping, so this section does not use the words such as knowingly, with knowledge, intentionally, or with intention. Okay, that means in order to commit the offense of kidnapping, mens rea is irrelevant. Okay, mens rea is irrelevant, which is the basic principle of committing a crime in our legal system. That you must do the crime with intention or with the knowledge, then only a crime is committed. We know that the mens rea plus actus rea, guilty mind and a guilty act, forms the basis of a crime. So in this case, because there is no mens rea, then also we are committing someone guilty of a crime. Why? Because we are bound by the act. Act says, act does not use the word knowingly or with knowledge or intentionally or something like this. So in order to commit the offense of kidnapping, mens rea is irrelevant. This person A may have no intention of taking this child out of custody. He may be just playing with a kid. He may actually wanted to buy the ice cream for the child. He had no bad intention at all. He was just playing. But this section says we do not want mens rea at all here. The moment you take child out of the consent, out of the custody, you are guilty. Okay. When someone tells you, people luring young people, let us remove the word lure young people. Let us say a people promising young children of work in cinema industry if they accompany him. That is a genuine promise. Now there's a 17-year-old girl, okay, a bit mature girl. She is not a, we cannot compare a 17-year-old girl to a 5-year-old girl. So she is a 17-year-old girl. Someone tells her that I'll take you to the movies and you will be a star and this and that. And he is also making a genuine promise. When he's saying so, he does not have any bad intention. He does not want to commit an offense to this girl. But he genuinely believes that girl has something which can make her a big star, and if given proper training, she can be the a big asset to the Bollywood or Tollywood or whatever industry. And girl also genuinely believes. But there is no permission of the parent. Parents don't permit it. Okay, but she still goes with the person. Voluntarily, she is going out of her own will. Okay, she says, yes, I will go. She took a decision after taking all the, considering each and everything. Then also, offense of kidnapping is made out. Then also, offense of kidnapping is made out, because in this section, when we are talking about kidnapping, we are not talking about what were your intentions, whether you wanted bad intention or good intention, whether you were acting genuinely or with malevolence or benevolence or whatever it is. Only thing required in kidnapping is enticing or taking away of unsound person or minor person, male under 16, female under 18, out of the lawful guardian and without the consent of such guardian. That's it. Whatever your intention may be, you are guilty of committing kidnapping. Okay, that is how seriously we treat this offense. Okay, that's how seriously we treat this offense. Even if you knowingly go with someone, law says, therefore, the consenting to kidnapping is immaterial. The girl goes to the court and says that no, I willingly went out with him, knowingly I went out with this man. Okay, my intention was there. She writes a letter, she records a video, whatever she does, and she goes out. And the parents are against, and parents lodge a complaint. The person is definitely guilty of committing kidnapping. Okay, because parents' permission is must, and we are not talking about guilty intention. Tomorrow, the person cannot say that because I had no mens rea, I actually wanted to make this girl a star. I had no mens rea, so why an offense? So law answers that we do not require any mens rea in such cases. Okay, because we do not use the word knowingly with intention, knowledge, or etc. Okay, so that means the offense of kidnapping is complete even if the girl is accompanying or the boy is accompanying you out of choice and you have no bad intention. The moment you take the child out of the guardian, custody of the guardian, the offense of kidnapping is complete. This is how seriously we tackle this meanness of kidnapping. Keeping includes times during which the minor is not actually physically with the guardian. Like I discussed that a child is out of the standing on a road, okay, out of the custody of the parents right now, but that will be considered in the keeping as well. Still he is in the keeping of the lawful guardian. Wherever a child may be, he is considered, he is presumed to be in the keeping of the lawful guardian. Lawful guardian, different from legal guardian, includes teachers, relatives, etc., who have been entrusted with the care of minor. Okay, legal guardian is parents. Okay, legal guardians are parents. Okay, and lawful guardian means whoever is acting as a guardian right now. Suppose parents drop the children to the school. Now teachers, they have given the custody of the children to teachers, or they drop them to relatives. They have given them to relatives. Okay, intention of the kidnapper is immaterial. Consent of the person kidnapped is immaterial, like we discussed here. Okay. It is a substantive offense, not a continuing offense. It is complete as soon as minor or unsound person is removed from the lawful guardian. It's a substantive offense, means the ingredients, as soon as the ingredients of the offense are complete, the offense is complete. Okay, it is not a continuing offense. Okay, it is not a continuing offense. It is a substantive offense. Okay, it is not that you take some child out of the custody and keep him for 40 days, then you will be guilty of committing 40 kidnappings. Okay, no. It is a substantive offense. Once it is completed, it is complete. It does not continues. Okay, and till the time child is not reunited, you are guilty. Okay. Taking doesn't necessarily means by force. Okay, merely means to cause to go, or to escort, or to get into possession. You are escorting someone, or you are making someone go, like we discussed, by false promises or by luring a kid with the ice cream. You are not forcefully taking, but you are making the person walk with you. Okay, that is also simply a kind of taking. Entice means an inducement or allurement by giving rise to hope or desire. Okay, you are giving allurements like we discussed in this case. That is called offense of kidnapping is complete. Vardarajan versus State of Madras 1965. The girl voluntarily joins the boy, and hence it cannot be said that he has taken her away from keeping of her lawful guardian. The proposal to run came from the girl's side. To the convict, to convict the accused, something more should be there. Some sort of allurement or active participation of the accused, information of the intention of minor to leave the house. Now, this is a very good judgment. Okay, now there are so many more judgments like this. This is the 1965 judgments. Law says here, if someone voluntarily joined your company, that will not be a kidnapping. Now, you may be thinking that here I said that consent of child is immaterial. Okay, when the consent of child is immaterial, or the what child is going outside, like I discussed in this case, 17-year-old girl willingly agreed, she herself went out. Okay, then why kidnapping in this case? Okay, and why no kidnapping in this particular case? Because we are trying to differentiate between two acts. Okay, in the earlier act, the girl is giving consent to go only because someone is alluring her, someone is enticing her, someone is making promises to her. She is herself, she does not at the first place herself believes that she is a superstar material, but someone gives her all those hopes and desires. Then she is going out. Okay, that means you are manipulating. Someone is manipulating the consent of the child. Then it will be an offense of kidnapping. But simply, a boy says, let's run away, and girl agrees and makes all plans. Kidnapping will not be complete. Okay, kidnapping will not be complete. Okay, because in this case the boy is not making any allurement, or he is not trying to entice away, he is not forcing the girl. It is girl himself who is agreeing and making all the plans to go with the boy. Okay, then this is not a case of kidnapping. This is girl is voluntarily doing something. This boy is, see, the act is have to be completed. You have to take away or entice. He is neither taking forcefully or neither enticing. Okay, just by sharing, just by saying let's run away, mere sharing of opinion is not enticing away. Mere sharing of opinion is not enticing away. Let's bunk the school and watch a movie. Okay. One student tells another student, boys, let's bunk the school and watch a movie. And the other person agrees and they make a plan and go and bunk. This is not a kidnapping. Someone shares an opinion, other agreed to it. Enticing is allurement. We are talking about allurement or inducement, giving rise to hope or desire. When you are alluring someone, okay, then only offense of kidnapping is complete. Simply by sharing of an opinion, it is not an offense of kidnapping. Even if girl is voluntarily going and joining the boy's company, then also it is not a case of kidnapping. Okay, but in order to prove kidnapping, you have to prove that boy took forcibly or enticed. Okay, he did something which manipulated the judgment of the girl or the boy. Okay, so now we are done with today's lecture. We'll meet again.